You're online, Evelyn.
Thanks. I just need to find something. It's not working as usual. There we go. Hi, everyone. It's Evelyn Ackah. I hope you're well. Thanks so much for joining me today on our LinkedIn Live. I appreciate your um, participation and joining me. Today, we're going to talk about a very important topic that many people avoid until it becomes really urgent. This is estate planning and immigration. People don't think that they go together, but they really do. If you are a newcomer or a temporary foreign worker or an international student, or even a permanent resident, a business owner, or part of a cross-border family, estate planning may not be the first thing on your mind, but you may need to focus on this. You may instead be focused on your work permit, your permanent residence, your citizenship, your family sponsorship, or business expansion, or settling into your life in Canada. But immigration planning and estate planning often overlap more than people realize. You need to think about things like what happens to your spouse, your children, your assets, your business, your property, your house, or your immigration file if something unexpectedly happens to you and you die or you become um, unable to make decisions. Who can make decisions for you if you become seriously ill? Who has the authority to manage your affairs? What happens if your family members have different immigration statuses? Could that impact their ability to stay together? Today, I'm going to walk you through estate planning matters for immigrants and cross-border families, what documents people should be thinking about, and the common mistakes families often make when they wait too long. Again, this is very general information. It is not legal advice. I am not an estate lawyer. Estate laws can vary province by province or territory, and immigration issues depend on the facts of each case. So let's get started. Immigration status does not replace your estate planning. The first thing you need to understand is your immigration status does not replace your estate plan. Being a temporary resident or a permanent resident or a Canadian citizen does not automatically answer questions about your assets, your children, your spouse, your business, or your wishes, your personal wishes, if something happens to you. Many newcomers assume that because they are young, healthy, or still building their lives in Canada, they don't need a will or an estate plan yet. But life can change very quickly. If you own a home in Canada, you have any savings, you have children, you operate a business, you have credit, or you support your family overseas, or have assets in more than one country, estate planning becomes very important. Without proper planning, your loved ones may be left trying to understand all these different issues. Who has legal authority to act on your behalf? Who can access your bank accounts? Who can manage property? Who has power of attorney over your children or your assets? Who can make healthcare decisions or financial decisions on your behalf or your children's behalf? And what happens to children if both parents cannot care for them? What happens to a pending immigration application if you become incapacitated or die? And what happens if the person who passed away was the main worker or business owner? These are really difficult questions, and they are much easier to address before there is a crisis. Nobody wants to think about this, but you have to. I have seen it happen as it relates to immigration, and it is devastating for the families and their friends. For many adults in Canada, there are three key estate planning documents that you must understand and you must have in place. The first is a will. A will allows you to say who should receive your property, who should manage your estate, and who you want to care for minor children. If you die without a will, provincial law will decide how your estate is handled, and you don't want that. That may not reflect your personal wishes or your cultural wishes and expectations for your family. It's really important that you have a will. The second document is an enduring power of attorney. This allows someone you trust to make financial or property decisions for you if you lose capacity or can no longer manage your affairs independently. For immigrants and international families, this can be especially important. If your spouse is outside Canada, if your parents are out overseas, or if your family is unfamiliar with the Canadian systems, The delays can create stress and confusion. And the third document you need is a personal directive, sometimes called a healthcare directive or advanced care directive, depending on the province that you live in. This directive allows someone you trust to make personal or healthcare decisions on your behalf if you cannot make them for yourself. These three documents are not just for older people, they are for everyone, adults who want clarity, control, and protection for their families. It's so important to have these three documents as soon as you get started in your life in Canada. Even if you have them back home, they may not be the documents you need. Estate planning can be more complicated for immigrants and cross-border families because life is often spread across more than one country. You may have family in Canada and overseas. You may have property in Canada and in another country. And you may have bank accounts in multiple jurisdictions. A business in Canada and a business abroad, children born in different countries, a spouse with a different immigration status than yourself, parents or dependents you financially support that are overseas, and a pending permanent residence or citizenship or sponsorship application in Canada. Any of the above can create practical and legal complications for you. For example, a will prepared in another country may not be enough for your Canadian assets, may not contemplate your Canadian assets. A family member overseas may not be able to easily manage Canadian property, bank accounts, or legal documents if they're in another country. A spouse may be grieving while also trying to protect their own immigration status if you pass. A business partner may not know who has authority to make decisions because you are now incapacitated. And a child's guardian may not have the immigration status needed to remain in Canada with that child that is a Canadian permanent resident or citizenship. That is why newcomers and cross-border families should not assume the documents from their home country automatically solve everything in Canada. You should get advice from a qualified professional in the relevant jurisdiction that you're living in Canada so that they can contemplate both your offshore or overseas estate plan as well as getting you a Canadian estate plan put in place. Another important point is that estate planning is not only about money or property. It can also affect your immigration planning. For example, if someone is being sponsored by a spouse or partner and the sponsor passes away before the application is complete, that immigration file may need urgent review. If a temporary foreign worker is the main permit holder and their spouse or children's status is connected to that worker, the family may need advice about what options are remain available to them. If a business owner has a work permit or is using a business immigration stream to stay in Canada, incapacity or death may create questions about business continuity and immigration compliance. This is very, very serious. If a permanent residence application is in progress and the family composition changes because of death, separation, birth, or adoption, or incapacity, IRCC may need to be updated. The key message is this: when a major life event happens, do not assume the immigration file will continue exactly the same way. Get advice quickly. A death, incapacity, or major family change may affect eligibility, documents, timelines, or strategy related to your immigration. For families with minor children, planning is even more important. Parents should think about who would care for their children if something happened to both of them. For immigrant families, this question may be more significant and more complicated. The person you trust most may live outside of Canada. They may not have Canadian immigration status. They may not be able to even visit Canada. They may need a visa or authorization to enter Canada. They may not understand Canadian school, healthcare, or legal systems. And they may not be able to act quickly in an emergency to help take care of your children. This does not mean you cannot choose somebody from outside Canada, but it does mean the plan should be practical. What happens if it takes them a long time to get to Canada on a visa? If you have children, estate planning should include both legal and immigration considerations. You may consider maybe having somebody in Canada also be a part of that plan in case it takes a while for people to enter Canada who you have designated as guardians. Families should also understand that when somebody passes away in Canada, there are administrative steps that may follow. A legal representative may need to file a final tax return. The estate may have to deal with CRA, Canada Revenue Tax, Service Canada, banking, insurance, pensions, property, and debts. There may also be potential benefits such as the Canadian Pension Plan death benefit or survivor's pension, depending on the person's contributions and the family's circumstances. For newcomers, this can feel overwhelming because the family may be grieving while also trying to navigate a system they do not understand. A clear estate plan can make this process much easier. It does not remove the grief, obviously, but it can reduce confusion, delays, and conflict. What are some of the common mistakes newcomers and cross-border families make? The most common mistakes include assuming estate planning is only for the wealthy and assuming that young families don't need a will or an estate plan. Assuming a foreign will automatically cover Canadian assets. That's not necessarily true. And not updating documents after moving to Canada. Another mistake is not naming someone trusted to make financial or healthcare decisions on your behalf and not planning for your children if guardians live outside of Canada. Not considering how immigration status affects a surviving spouse or dependent, and not reviewing sponsorship or permanent residence files after a major family event. Not planning for business continuity if you're a business owner and you have partners, or waiting until there is a medical emergency or death before asking questions. But the biggest mistake is waiting. Estate planning is not about expecting something bad to happen. It's about protecting people you love if something does happen. If you are a newcomer, permanent resident, or a foreign worker in Canada, or an international student, entrepreneur, or part of a cross-border family, here are some questions that you must need to review. Do I have a valid will in Canada? Do I have assets in more than one country? Who would manage my estate if something happened to me? Who would make financial decisions if I become incapacitated? Who would make healthcare decisions for me? And who would care for my children if I'm unable to care for them? Does that person have the ability to come to Canada urgently if needed? Is my spouse's immigration status connected to mine? Do we have a pending sponsorship, permanent resident, or work permit application? Would my business continue if I could not run it? Have I updated my plan since moving to Canada? These are not always easy conversations to have, but they are responsible conversations that must be had. Common mistakes newcomers and cross-border families make. One of the most common mistakes is assuming estate planning is only for older people or wealthy families. In reality, estate planning is important for everyone building a life in Canada, even if you rent, even if you don't have a lot of assets, but you have children, you have a spouse, you have property, you have things that people need to manage after you are incapacitated. Another mistake is relying only on documents from your home country. A foreign will may not always work smoothly for Canadian assets, property, or bank accounts, and it can create significant delays for your loved ones who need to survive after you are no longer capable. Families also forget to update their plans after major life changes, such as moving to Canada, getting married, getting separated, having children, buying your first house in Canada, starting a business, or applying for permanent residence or Canadian citizenship. For immigrant families, guardianship can also be complicated. The person you trust most to care for your family may live outside of Canada or may not have Canadian immigration status. Another mistake is forgetting that death or incapacity can affect immigration matters. If a sponsor, principal applicant, or work permit holder passes away, the family may need urgent immigration advice. The biggest mistake is waiting until there is a crisis. That's too late. Estate planning is not about expecting the worst. It's about protecting your family, your wishes, and your future. Estate planning and immigration are both about the future. They are both about security, stability, and protecting the people who depend on you. If you are building a life in Canada, sponsoring family, working temporarily, applying for permanent residence, or running a business, or managing assets across borders, do not treat estate planning as an afterthought. Speak with an estate planning lawyer and an immigration lawyer so your documents, your family, and your immigration strategy all work together. At Ackah Business Immigration Law, we help individuals, families, and businesses grow beyond borders with clarity, confidence, and care. Caring about your estate plan is a part of that process. We work with outstanding professionals who can help you get the estate plan that you need. I want to tell you about a case that occurred that's just so tragic. We had a client, he's a Canadian citizen, and he married a Mexican citizen and was living in Mexico, and they had a child in Mexico as well. And he got sick, and they decided to come back to Canada. While living in Mexico, he did not sponsor his wife. He did not get his child registered as a Canadian citizen. None of that happened. So they entered with him and his family as visitors. And he got very, very sick and he actually died. And it was so tragic because we had to deal with the process of unraveling everything. And for this poor woman who had just lost her husband, the father of her child, to have to deal with immigration and to find out she couldn't be sponsored because he had died. And then we had to do the citizenship application for the child, which we were able to do. And we also brought in help to help her with her Mexican estate issues because he didn't have a Canadian estate in place at all. And in the end, the whole family, the wife and the daughter, had to return to Mexico because they didn't have the opportunity to live in Canada. I mean, the mother couldn't be here, except as a visitor, even though her child was deemed to be a Canadian citizen. And we got citizenship for that child. It was such a tragic story. And I tell this story so that you understand the importance of having a Canadian estate plan. It should go hand in hand with your immigration plan. Please do give us a call if you have any questions. As I said, we work with outstanding immigration wills and estates professionals, and we can work together to get your plan in place. It's not very expensive, and it is essential to protect you and your family and your assets. Thank you so much for joining me today on our LinkedIn Live. I hope you take good care, and I look forward to having you join me for our next live. All the best. Bye.